Be ready. Start. Each case entails a different set of facts, and a decision is a precedent on its own facts. Not everything said by a judge while giving a judgment can be ascribed precedental value. The essence of a decision that binds the parties to the case is the principle upon which the case is decided, and for this reason, it is important to analyze a decision and cull out from it the ratio decidendi. In the matter of applying precedents, the erudite Justice Benjamin Cardozo, in The Nature of a Judicial Process, had said that if the judge is to pronounce it wisely, some principles of selection there must be to guide him along all potential judgments that compete for recognition, and almost invariably his first step is to examine and compare them. It is a process of search, comparison, and little more, and ought not to be akin to matching the colors of the case at hand against the colors of many sample cases, because in that case the man who had the best card index of the cases would also be the wisest judge. Warning against comparing precedents with matching colors of one case with another. He summarized the process in case the colors don't match in the following wise words: it is when the colors do not match, when the references in the index fail, when there is no decisive precedent, that the serious business of the judge begins. He must then fashion law for the litigants before him. In fashioning it for them, he will be fashioning it for others. The classic statement is Bacon's: for many times the things deduced to judgment may be meum and tuum, when the reason and consequence thereof may trench to point of estate. The sentence of today will make the right and wrong of tomorrow. According to the well settled theory of precedents, every decision contains three basic postulates: 1. Finding of material facts, direct and inferential. An inferential finding of facts is the inference which the judge draws from the direct or perceptible facts. 2. Statements of the principles of law applicable to the legal problems disclosed by the facts. And 3. Judgment based on the combined effect of the above. A decision is an authority for what it actually decides. What is of the essence in a decision is its ratio, and not every observation found therein, nor what logically flows from the various observations made in the judgment. Observations of courts are neither to be read as elucids, theorems, nor as provisions of the statute, and that too taken out of their context. These observations must be read in the context in which they appear to have been stated. Judgments of courts are not to be construed as statutes. To interpret words, phrases, and provisions of a statute, it may become necessary for judges to embark into lengthy discussions, but the discussion is meant to explain and not to define. Judges interpret statutes, they do not interpret judgments. They interpret words of statutes, their words are not to be interpreted as statutes. It is also important to read a judgment as a whole, keeping in mind that it is not an abstract academic discourse with universal applicability, but heavily grounded in the facts and circumstances of the case. Every part of a judgment is intricately linked to others, constituting a larger whole, and thus must be read keeping the logical thread intact. The ratio decidendi of a judgment has to be found out only on reading the entire judgment. In fact, the ratio of the judgment is what is set out in the judgment itself. The answer to the question would necessarily have to be read in the context of what is set out in the judgment and not in isolation. In case of any doubt as regards any observations, reasons, and principles, the other part of the judgment has to be looked into. By reading a line here and there from the judgment, one cannot find out the entire ratio decidendi of the judgment. While distributing natural resources, the state is bound to act in consonance with the principles of equality and public trust and ensure that no action is taken which may be detrimental to public interest. Like any other state action, constitutionalism must be reflected at every stage of the distribution of natural resources. In Article 39(b) of the Constitution, it has been provided that the ownership and control of the material resources of the community should be so distributed so as to best subserve the common good, but no comprehensive legislation has been enacted to generally define natural resources and a framework for their protection. Thank you.